Hello, ladies and gentlemen. May I welcome you to this webinar and thank you for participating. It is one of a series of webinars, conversations organized by African Arbitration Association. And I think this is the second one. And at this way, I just commend the hard work of the Secretary General of AA, African Arbitration Association, Dr. Rukia Baruti, for putting all these efforts together and making all this happen. Today, I have with me barrister lawyer Godwin Omoaka, a senior advocate of a Nigerian SAN, which is the equivalent of Queen's Counsel in the United Kingdom. He is a fellow of the Chartered Institute of Arbitrators, a CEDA accredited mediator, and a partner at a very successful law firm, Templars, a renowned law firm in Nigeria with very successful arbitration practice. Godwin Omoaka also sits on the board of the Lagos Court of Arbitration and is a governing council member of the Institute of Chartered Mediators and Conciliators. Well, at this point, may I just ask, Sir, God, how would you like me to address you going forward? Because you have all these letters and titles after your name. How do you prefer me to address you going forward?
Julius, good evening. Please ignore the letters and titles. I like to keep it simple, so just call me Godwin.
Okay, thank you so much. Thank you so much. That really makes my job easy. So this evening, Godwin will be sharing with us his experience in building an arbitration practice in Nigeria and Africa, particularly from the perspective of growing from an associate to a partner and a senior advocate of Nigeria. He will also share his views on some of the pertinent issues surrounding arbitration practice in the continent. This session is going to last for an hour altogether, and the interaction between Godwin and I will last for approximately 35 to 40 minutes, and then we will take questions from the attendees. Now, we will proceed by way of some questions to Godwin, and he will give answers to them. The question and answer panel is there. People with questions could be putting in their questions there in the meantime. So without spending any more time on the introduction, Godwin, could you please tell us about your journey? Quite a successful man. You have a successful practice. Being a SAN, a senior advocate of Nigeria, is not a child's play. It's not a day's job. So tell us, how was the journey?
Julius, thank you for all the accolades. As with every other journey, it was a very challenging journey, but it was a very interesting journey as well. And it all began because I love challenges. And one of the things I did very well is to face challenges, especially when you work in a firm like mine. You understand? One of the things that would definitely take a young lawyer to the top is to be able to give clients, and especially for young people, solutions that meet their specific needs. So you must be able to think out of the box. You must like those intriguing and challenging situations and be able to provide practical solutions to the client. So I love those kind of challenges. I think I excelled in them. That was one of the main drivers for me, climbing the ladder very quickly. Also, coming through the ranks, I had my goals, all right? I knew I wanted to get from point A to point B within a specific time frame. I call it my stretch goals. So what did I do? I had people I call accountability partners. within the firm with whom I work together. And from time to time, we will measure where I was, what I've attained, because I knew if I followed those objectives, those goals, it would get me to the top. So that was one thing I did. Another thing I think I did very well was to build an excellent professional network. Now, arbitration is a secondary profession, as you know, so you must have a good network of people that you can contact, that you can reach, that can help you develop your practice. That even when you need an opinion, you can call them, especially in allied fields and professions, and then they'll give you their opinion. So that was very, very important for me. And again, we're in a business. Don't forget that this is a business. Law practice, arbitration, it's all a business at the end of the day. So people must be commercially aware, especially for the young ones who want to grow, who want to make that giant step forward. They must be aware of the daily commercial activities and business activities, what is going on around them. They should have that. It's very, very important. That critical industry knowledge will help you excel. And then, of course, if you work in a firm like mine, within a partnership, then you want to own part of the business. And how do you own part of the business? You want to see yourself not as an employee, but as part owner. You have a stake in the business. And so you want to put in your best to grow the business when the practice, wherever you are. For instance, you go for trainings, conferences, webinars, seminars, you're always projecting yourself. You're always projecting your firm. It's very, very important. Okay. Then as well, you need to carve a niche for yourself. This is very important. Carving a niche for yourself as a young person is very important. Because, I mean, if you're in a practice where everybody is doing the same thing, then you may just be lost in the crowd. So it's important that you own some aspect of the practice and then run with it and excel in it.
All right, thank you so much. I think you've given quite a lot of information of how your journey has been, and in the audience today, the attendees, it's made up of people, young people who are getting into arbitration, but not only young in terms of age, but in terms of the career progression. Yeah. And somebody who's been doing something else for the past 30 years could be sitting here and asking themselves, well, can I get into arbitration? So the question I have for you in that regard is, have you ever always wanted to do arbitration from when you left law school?
Good question. To be honest with you, at the time I left law school, I didn't know much about arbitration, right? But after law school, I got into this firm, which is a top firm in Lagos as well. And when I got in there as an associate, two of the partners happened to be ardent arbitration practitioners. And I saw how they progressed their career in arbitration, how they became involved with the various arbitration institutes, you know, and both locally and internationally, always attending seminars and conferences, and that whetted my appetite for arbitration. And that's how my interest in arbitration began. Sadly, I didn't have the opportunity while in that firm, you know, to be involved in the process. And not too long thereafter, I moved to Templars, where I've been ever since. And we got in there. When I got into Templars, it was at the time when we were just beginning to build our dispute resolution practice. And of course, arbitration was naturally going to be part of that mix, you know. So we set up building the arbitration practice, strategizing and all of that. And something remarkable happened. I recall we got two instructions, you know, in respect of one, an international arbitration, and the other one, a domestic arbitration. And so I was thrown into the deep end, you know, and I mean,
So in essence, you're saying that it doesn't really matter when you want to start. It doesn't matter whether you're just leaving law school with arbitration in your head, or you've been practicing something else for many years and you decide now to get into arbitration. All is fine, so long as you put in the commitment.
Yeah, it doesn't matter when you start. All you need is the commitment, the competence, because you need the training as well. Okay. Because without competence, you can excel in anything.
Yes.
So you need that, and it doesn't matter when you start. It's never too late. Anybody can start today, whether you're 40, whether you're 50. It's never too late. So it's important, and that was how my arbitration journey began. And to be honest, we won those cases. And so it fueled my interest further. And then after that, I began the formal training process of being trained formally and being certified as a professional in the field.
Okay, good, very good. So, what would your message be to a young practitioner to achieve the kind of success that you have in arbitration?
Well, we get asked this question most times. What will your message be to young practitioners? I think my chief message will be a few. First, you have to have the expertise. It's very, very important. You must have knowledge. Because one thing you will find in this industry is that you will never get an appointment either as a counsel or as an arbitrator if you are not competent. So everything is built, in my view, is built around your competence. So you must display that. And one way you can acquire that is by attending trainings, conferences, webinars. Ensure that you have the necessary competence to be able to deliver when you're called upon. Then it's important for a young arbitrator to have mentorship as well, because it's very important. It's good for you to have someone you can look up to, someone that can inspire you, someone that can guide you, hold your hand and guide you all through the way. Also, it's also important for a young arbitrator, for you to succeed, you need that network, professional network. Let me tell you something, Julius. You can't succeed without the network. It's very important, because that is what will give you your cases. So this network, particularly in-house counsel, parties, and external counsel, foreign counsel. Very important. Most times you see people attending conferences and webinars, networking. That's the whole idea. But you must nurture that relationship. Those relationships must be nurtured, and you must always be in their faces as a young arbitrator. I think one of the feedbacks I got while at Templars, when we were building our arbitration practice, was that we were constantly too aggressive, because we were always, knocking on the door of in-house counsel. We are always knocking on the door on foreign counsel, because these are the people I call the influencers, the powerful influencers in the profession. So when there's a dispute, you want to be among the first, or the first three to be called upon, in their mind. So that's very important for a young arbitrator, to be able to have that network, build on it, nurture it, to be able to get appointment either as counsel or appointment either as arbitrator.
Yeah, you say that, Godwin, it sounds easy and it sounds so sweet, but in practice, it may not be the same. You've talked about training, you've talked about networks, and these trainings, as you and I know, once they are advertised, they come with a price tag to them, and these prices are not usually cheap. How would a young arbitrator balance between trying to do all these things, these trainings, networks, which come, as I said earlier on, huge price tag, and actually gaining that excellence, that the practice, as it were, and perhaps bringing the bread and butter to the table? How do they balance it?
I would say two words: intentional and focus. In the sense that, it's costly, like you rightly pointed out, to attend arbitration conferences and seminars, to attend the trainings. Some of these things you get to pay in dollars at times, and a young professional may not be able to afford this. My suggestion would be that they have savings. They should keep money aside to be able to attend conferences and seminars. But then you can't attend everyone. So you have to be focused, you have to be intentional, you have to make a decision which you want to attend. So budgeting, keeping money, saving money is very important. Another thing I think I would encourage a young practitioner to do is to reach out to mentors and establish successful practitioners for sponsorship if they want to attend a conference, particularly within their locality, within their country. It's important. I've been in situations where young arbitrators have approached me, some of them from the university, some young lawyers have approached me to say, look, I want to attend this conference. I don't have the funds. Can you support me? And I was very glad to do that. And I'm always glad to do that. And I'm sure a lot of the successful and established arbitration practitioners will be happy to do that. It's part of giving back, you know, to the young ones. So I think these are two important things I would suggest to them, you know, for them to be able to raise the funds to attend these conferences and seminars.
Good. Thank you very much. I think you're right. Asking mentors and asking for support from people who are slightly better off in the practice to attend some of these seminars works as well, because I've had a couple of people approach me over the years, and for some reason I managed to find some help for them, which they have been forever very grateful for. Now, and you said people should attend even one conference a year, and I'm saying that if it is only one a year, which are you going to recommend? Because I know the one I'm going to recommend. Which one are you going to recommend?
I recommend the one for AFA. I don't say I'm being biased now.
All right.
Because that's the conference that brings together arbitration practitioners in Africa, right? Together. And it's unfortunate the one for Ghana this year didn't hold, but that's one I would definitely recommend.
Fantastic. I'm sure you're going to you'll be earning a brownie point from the President General of AFA, Bayo Ojo-san, who might be on this call. Now, you have said, oh, so far so good. So are there any challenges in arbitration practice in Africa or Nigeria particularly, or Africa generally?
Well, there are quite a lot of challenges, significant challenges that we face with regards to arbitration in Africa and Nigeria in particular. I think one of the foremost challenge will be our domestic arbitration laws. I mean, there's a need to constantly review them to bring them up to speed with international standard and best practices. Because of the state of the laws, we've seen that I mean, lawyers, counsel who are dissatisfied with an award have tended to exploit the weaknesses in those laws to frustrate arbitral proceedings, the enforcement of arbitral awards, and all of that. So I think that's one thing I would say is a challenge. We need to address that. Secondly, I would also talk about enforceability of arbitral awards. The only reason and the main reason why a lot of people resort to arbitration as an effective dispute resolution mechanism is because of enforceability. The New York Convention, you can enforce it, especially if a party to your country is a party to the New York Convention, you can enforce the award anywhere. But what we have found increasingly in Africa is that, especially in Nigeria, and I've had this experience personally, is that counsel most times when they lose, they place all sorts of procedural roadblocks towards enforcement of awards in Africa. So we need to look at that and the role of the judiciary as well. If we challenge to arbitral awards lasting as long as 9-10 years. I participated in an arbitration in 2011. As we speak, we are in the Supreme Court. We've not been able to enforce the award, right? There was another award I got in 2017. It's still, we've not been able to enforce it because of this sort of challenge by lawyers who see the set-aside process as a means to really litigate, you know, the whole arbitral award. So that is the challenge. I think, thankfully, I speak for the Nigerian judiciary. There are challenges, but they are rising up to the occasion. The more our judges have been continuously being trained in arbitration. Their pronouncements are increasingly more pro-arbitration, even though now and then you find one off-the-mark pronouncement here and there. But generally, they tend to support and encourage the process. So I think these are two of the challenges that we face mostly in Africa in terms of arbitration.
I'm sure you will tell us a bit more about the sort of the here and there one-off decisions when we get to that question, because in my head already I'm thinking about the case of global gas. That I'm sure while we're still at the challenges, do you have anything to say about representation in terms of diversity, men, women, young and not so young, and black, white? Is there anything you can say about in terms of challenges in that area, equality and diversity?
Yes, it's a massive challenge, and over time we've seen that the question of diversity in arbitration, especially from an African perspective, has been in the front burner for a long time. I've seen statistics lately that shows that Africans have not been given their fair share of representation in international commercial arbitration. So that's a challenge, and we need to address it. I'm aware that there are a series of initiatives, to address this issue. I'm aware of the African Promise, which is a pledge, by corporates, by arbitration users, to ensure that African representation in international commercial arbitration is addressed in terms of the profiling and the representation of Africans in international commercial arbitration, and then having Africans appointed on an equal opportunity basis. I think after the last time I checked, over 320 users have signed up to the African Promise pledge. So that's a commendable objective, right? So yes, there's a need for, it's a challenge. We have to address it. Steps are being taken. It's not enough. Let me give you a statistics that I have here from last year, from the LCIA. They say there were 346 cases decided under the LCIA rules. 10.2% of those cases had connection with Africa. 10.2% of those cases are connected to Africa. And of those cases, only 4 arbitrations were seated in African jurisdictions. So that's a very grim statistics, and it tells you the reality of what we're facing with. And many at times you hear people come up with different sort of excuses, saying, oh, there's a lack of expertise and experience in Africa, which I'll completely disagree with. We have one of the best arbitration industry community in the world. We have a lot of expertise and experience there. Then, of course, there's bias in favor of foreign counsel, and also something I find I'm not very happy about is the fact that Africans, we don't get to appoint ourselves frequently as arbitrators, in African-related or African-connected arbitrations. So much as we are preaching diversity to the outside world, we have to look inward as well to encourage ourselves to be able to appoint Africans. And I think if we do that, then the international community will, of course, be forced to do that as well. So I think these are some of the issues we need to do. And again, for the corporates, I think we will need to, with respect to the diversity issue, just as most of them have this diversity policy in their organizations. I think also they have to employ it when it comes to arbitration, when it comes to appointing counsel in arbitration, when it comes to appointing arbitrators in arbitration. They have to apply diversity and be transparent about it, whether in terms of nationality, whether in terms of women and young persons. So
okay, I think that is quite exhaustive, and thank you for that. Just while we are on equality, Templars is a renowned law firm in Nigeria. In fact, it's got international status. Can you say anything about equality and diversity at Templars?
Oh, sure, great. So we live what we live what we teach at Templars, right? I don't know the exact figures, but I think we're 100+ law firm, a law firm of about 100 plus lawyers. And I can tell you that I think it's about 50-50 or slightly 50 in favor of the ladies, not the men, in favor of the women in terms of women who are working in Templars. And if you look at the age spread, the age band is between 21 to 44 for the women. So I think we are a good example of how diversity should be.
That's quite impressive. Now, yes. On that very happy note, we move a bit to a more happier note, the Continental Free Trade Agreement, which is one of the biggest agreements, trade agreements in the world. In fact, it's the biggest trade agreement in the world. And it is anticipated that out of these deals that will be going across 54 states, disputes will follow in large volumes, and possibly a huge amount of these disputes will be resolved by way of arbitration or mediation, given that the Singapore Agreement is now around and there's all that is said about it. So do you think, in your view, that that is going to increase or improve the chances of Africans doing plenty of arbitration within this continent of Africa?
Well, I think it would. It should ordinarily, because don't forget, these are an African initiative, and then when you have the investors coming here into Africa to invest, once you have investors, ultimately down the road, it may not be immediate, you have dispute, right? And so when the dispute crystallize, the state parties will then be able to activate the dispute resolution mechanism under the AFTA, which is the dispute settlement protocol. So I have no doubt in my mind that the disputes will arise. It is important that when those disputes arise, that Africans are well placed to take advantage of those disputes. We have to interact with our state, with our home, with the governments of the various African countries if there are disputes under the AFTA, because don't forget, it is only the states under the state parties under the AFTA that can actually trigger the dispute resolution process under the AFTA, even though for the benefit of their own citizens and companies. So it's very, very important that we interact, we engage government departments, so that when disputes begin to come from the AFTA, then we'll be in a position to have those disputes resolved. And I'm hoping that, talking about diversity generally now, and AFTA to one side, I'm hoping that someday, just as we have seen all over the world with North America and Western Europe, I'm hoping that someday we will see an international commercial arbitration panel that all the arbitrators are Africans. I'm hoping that one day we'll be able to see that.
Good. That is quite good, and I look forward to that too. But while we're still after, I mean, you've said that the dispute resolution mechanism, which is in place now, is to do with the states. That's quite rightly so. But most of the disputes which are likely to come will be from the commercial sector. That is, a particular company from Nigeria doing deal with a particular company in Rwanda, and so on. That has nothing to do with the government. Yes. So commercial arbitration is going to be times 10 that what it is today. So what is your message to people who are getting into arbitration? Should they have their eyes on the balls right away, or should they wait any longer?
No, have your eye on the ball right away is part of the commercial awareness that I told you about. This is a business. So, I mean, it's like you have to keep tabs with everything that is going on. You have to be sure. We've had, in my firm, we have a lot of inquiries about the AFTA. People want to come to take advantage of it. So already there's a lot going on. You just need to keep your eye on the ball. You can't take your eye off the ball, because if you do, you may just get lost in transit. So the most important thing is being there, playing in that space, being relevant, so that if any dispute should crystallize, then of course you'll be one of the, the young arbitrator or whoever will be one of the persons that will be called upon to play in that space. So it's very, very important that we don't lose track of what is happening in that space.
And of course, a very important part of it is that when all the deals and contracts are negotiated, lawyers like you, arbitrators like you are there from the word go. There is always the kind of quiet and creepy side of it that people always ignore till when a dispute arises. And that is the arbitration agreement that will deal with the number of arbitrators, the seat of the arbitration, the language, and so on. That is usually very quiet, and we only find that out in the middle of, when the dispute arises, which means that I'm sure you will lead others and encourage others to have their eyes there. We really want arbitration to be seated in Africa and all those sort of things, because it is during the drafting of the agreement that all those things are dealt with. Wouldn't you agree?
I agree completely. I agree with you, Julius, completely. You just put your finger at the heart of the problem. And I've had considerable experience in this regard. What we find out over time is that when investors are coming into Africa, from the constructing stage, they're already instructing the international law firms, the Sherman and Sterlings of this world, the White and Cases of this world, the Clifford Chances, the Freshfields, right? At the time of contracting. And these are the firms that primarily are responsible for drafting the arbitration clauses. And what do we find out many a times? They protect their interests. So most times they put the seat of arbitration London, Paris, never in Nigeria, never in Ghana, never in Kenya. And if you don't have
Cameroon too.
Never in Cameroon too. Apologies, Julius. Never in Cameroon too. And if you don't have African council, because we are called local council, if you don't have local council pushing back on those arbitration agreements, then ultimately what you will find is that when a dispute eventually crystallizes, the arbitration is seated in the UK. There's nothing you can do about it. It is connected with Africa. It originated from Africa. And then the seat is the UK, it is Paris, it is Switzerland, it is wherever. So I think it behoves us as lawyers who are practicing in this space to continually try to push back on this sort of practice. Many a times the response you will get is that he who pays the pipe dictates the tune, and that is the truth. And then foreign counsel themselves are trying to protect themselves, because for them, they're drafting these clauses and they see that in the future, when a dispute comes, they want to remain relevant. They want to play in that space. They want to be able to appoint local counsel and have the arbitration seated in their own country. So I think it's a problem which we need to address, and we have been pushing back. And I hope those of us who are in the legal space, the big law firms around Africa, the Africans continue to push back on that, so that we get a lot of these arbitrations seated more in Africa, and then we can have African practitioners on them as well.
Good. Thank you so much. And in that regard, we will all be looking up to successful practices like Templars, because you are right at the heart of it from the word go.
Trust me, we're already doing our bit in that front. We're already doing our bit.
So in the course of the responses that you've given, you've talked about one-off decisions that may cause trouble, difficulties. You've also talked about judges' experience and trainings and so on. We have also, you've talked about challenges, why sometimes people prefer to take their arbitration seated somewhere else apart from Africa. And one of the reasons they will give, which is generally not true, is that you have arbitration-friendly countries and arbitration countries that are not so friendly to arbitration. You know, in arbitration, the national courts play a very important role in the process. And so people will say that they want to go to countries where the court system is good, judges know what they're doing, and so on, and when there's arbitration. they will not have difficulties in getting assistance from the court. Now, on the 25th of February this year, there was a judgment handed down in the High Court of Lagos in Nigeria, and it is the Global Gas Refinery case versus Shell Petroleum Development Company.
Yes.
And that has been, all over the place, big noises about it. And the big question that has come out of it is whether Nigeria is pro-arbitration or anti-arbitration. What side of the fence do you sit on?
I mean, my position is very clear. Let me preface my comment by saying that, look, Nigeria, the body of jurisprudence coming out of Nigeria, right, on this issue is pro-arbitration. Pro-arbitration. Nigeria is a pro-arbitration country. Our courts have done exceedingly well in supporting arbitration in their judgments. Even in the practice direction, I think a few years ago, the Chief Justice of Nigeria gave a directive that cases with arbitration agreements, the courts should not take them, and they should be referred to arbitration. We thought the Federal High Court in Nigeria, in response to that, amended their rules and included that in the rules, so that if there is an arbitration agreement in a contract, then the court must refer the dispute to arbitration and not entertain it. Now, coming to the global gas case, but before that, let me just say it again. If you do a statistical analysis of the judgments emanated from the Nigerian courts, even the Lagos court, where the judgment came from, you find out that it has largely been in support of arbitration. So I see the global refinery case, the global gas refinery case, and SPDC, as one of those one-off bad divisions. And I think so much weather, has been made of it. It's an unfortunate division in the sense that the judge came to the conclusion in that case that because the presiding arbitrator refused to disclose certain relationships, right? Then he had misconducted himself, and therefore the judge set aside the arbitral award on that basis, on the ground that the presiding arbitrator ought to have recused himself from the arbitration the moment his impartiality and independence was challenged. So undoubtedly, it's a very bad division, and I'm happy that it's been appealed. But like you will find across all the countries of the world, courts give very wrong divisions every day. And that's why you have the appellate process there anyway to correct those divisions. So for instance, if a wrong division is given, and we've seen a few by the UK courts in arbitration, does that make England an unfriendly division? No, definitely no. So I think it's the same principle we should apply here to Nigeria. I don't think Nigeria is an unfriendly arbitration country, notwithstanding the challenges we face and the division in the global gas case. But before I end that point, I think I should make a point about the global gas case, which a lot of people have overlooked. If I recall, one of the arguments in that case was that because the dispute was referred to the ICC, and the ICC did not disqualify the presiding arbitrator, the lawyer argued before the judge that the court should assume jurisdiction and try the matter, and that they were no longer confident in the arbitral process. But the judge rejected that argument and held that there was an arbitration agreement between the parties, and upheld the validity of the arbitration agreement, because that was the roundabout way to strike at the validity of the arbitration agreement. And this same judge, who has been criticized for that pronouncement she made, upheld found that the arbitration agreement is valid, and that even if the award has been set aside, the parties can go back to arbitration in accordance with the agreement. Yes. So I think that shows that it's just a bad decision that she came in, and it shouldn't necessarily affect the perception of Nigeria as an arbitration unfriendly country.
Yes, I think I agree with you absolutely. It is a one-off. It is an unfortunate decision, similar to the Ohada case of Getma International versus Republic of Guinea, which for 2 years was all over the place and so on. Sometimes these mistakes happen. But I think the unfortunate thing with this global gas case is it is happening at a time when guerrilla tactics in arbitration is going up. So if that becomes law, then the so-called competence, which is one of the rock stones of why people want to go for arbitration, is all dissolved and in the drains. But I am hopeful that the appeal, the Supreme Court will overturn that, and we will come back to...
I think even the Court of Appeal, and I'm confident that the Court of Appeal will overturn that division, because like you rightly pointed out, I mean, the competence principle, that the tribunal has the jurisdiction to determine its own jurisdiction is a fundamental cornerstone of arbitration. And it's just unfortunate that we have this decision striking seriously at that. But I'm sure that at the Court of Appeal, that judgment will be set aside and everything will be fine.
Yeah, because if it isn't, then we will find ourselves in the situation where, you know, losing parties will always want to look for ways to challenge an award and so on. There will always be challenging arbitrators, as you know, as I said earlier on, guerrilla tactics in arbitration will just come into play. Anyway, thank you very much for all those very useful answers and arguments you've put forward to encouraging people to get in the arbitration industry. It is never too late. It is time when the Trans-African Trade Agreement, the biggest in the world, is coming up. There will be so many disputes that we will be, you know, will not be able to deal with if we are not properly ready for them. So people who are interested in getting into arbitration, AFA is there. Contact them, contact other practitioners, and help is always available to getting on board. I'm going to open up now for questions from the attendees. And there is the first question. I'm going to perhaps put Bayo Ojo live. If he wants to ask the question himself, I'll make him a panelist so he can put the question through. Just yes, Mr. Bayo Ojo-san, you're now been made a panelist. Just to say that he is the President General of African Arbitration Association. Could you kindly put your question now to Gordon, please? Hello?
It looks like Chief is muted.
Oh, all right. Let me see. How is, okay. Hello? Oh, I can't do that from this end. Okay, I think I'll just go ahead and read it. The question is, Godwin, what is the solution to the challenge of lawyers clogging the process of arbitration by unnecessarily frustrating successful parties from reaping the fruits of their success? Chief Bayo Ojo.
The way I would address that question will be more of, I see it more as an attitudinal question, attitudinal issue. that will need lawyers to be educated, to be enlightened about the arbitral process itself. It's very important that lawyers understand what arbitration is, how it works, and the benefits. Because no, you can never have any perfect system of laws, all right? Laws will always have gaps that people can exploit. So I would think that we need to continue to retrain our lawyers. We need to continue to make them aware that this sort of attitude will not encourage foreign investors to continue to invest in this country if they see that the dispute resolution process is being frustrated by counsel who file all sorts of frivolous procedural applications. So we need that education. Then, like I said previously, we also need to look at our body of our arbitration laws to see how we can plug the gaps so that as much as possible, we de-incentivize the process of lawyers having to file frivolous applications. For example, let me give you a good example. I was involved in an arbitration. I think this was widely reported, where involving a state party, where counsel from the get-go didn't want the application to progress and then challenged the presiding arbitrator. The presiding arbitrator ruled on it, and counsel went to the Federal High Court. But of course, the Federal High Court judge had an arbitration background, and so he threw away that challenge and said that he shouldn't interfere in the process. But that had one effect. It stalled the process for more than 3 years, almost 2 to 3 years, right? We were just at the preliminary stages because of that challenge. So I think enlightening lawyers is important. I think plugging the gaps, the loopholes in the law, and happily in Nigeria, we have a draft arbitration bill that is before the House of Representatives right now, that has been passed by the Senate, that has sort of addressed some of the issues. And also, I am looking at perhaps a cost element, a sort of punitive cost element, again, by the courts themselves. Because if the courts continue to give pro-arbitration stand, then cost would be a good basis to discourage lawyers.
Cost is usually a weapon, because what you find happens is day one of a trial, you see the parties turn up with all the big lawyers like SANS, the QCs, and so on. But when the arbitrator says, well, I'm going to cap the costs, the next day they all disappear because
they all disappear. So cost is a very potent factor. And one other point I would mention in answer to Chief Ojo is that I hope we will see also an amendment to our laws, probably the Constitution, in such a way to make, and the Arbitration Act in such a way to make the Court of Appeal the last resort for all arbitration-related matters.
Okay.
So that it doesn't get
there is another important comment here, Godwin, that you may have something to say about. And this is from Kevin Medza, Senior Counsel at Great James Street Chambers in London. Says, perhaps African governments could make it easier by requiring homegrown representations within arbitration process in order to seal deals that involve African resources. What do you say about that?
Oh, absolutely, I agree. And that's why I talk about engaging with government departments, state parties. It's very, very important. Because if you don't make that a precondition, then Africans will continue to be shortchanged, in the process. So it's important that our governments understand that there's some sort of self-interest preservation at play here, and should be able to play the game as well. So I think it's very important that we do that. I agree completely.
Okay, fantastic. Moving forward, there is another comment and question from Amechi Nsofo from London. I work in the enforcement of arbitration awards. In Africa, the weaknesses in enforcement procedures means that a judgment isn't worth the paper it's written on. God. What changes would you make to enforcement procedures to enhance the arbitration, to enhance the arbitration process? Or is your view that this isn't a key factor?
No, it is a key factor. It's one of the issues I raised when I talked about enforceability, that the whole idea of arbitration is because it is enforceable all over the world. I mean, once a country is a signatory to the New York Convention. So, and this question also has a correlation with the point Chief Bayo made in his question. Because at the end of the day, we have seen that once arbitration awards are handed, at least in Nigeria, as I know, parties, mostly lawyers, begin to frustrate the process of enforcement by challenging that process. So while the Arbitration and Conciliation Act, allows them to do that, to bring the challenge application, what I will be saying is that lawyers, judges have to understand the importance of arbitration and be educated to know that this process has to play out quickly. Secondly, we need to look at the laws, which we are doing right now, to plug those gaps that allow this to happen. For instance, I know under the new arbitration bill that's before the House, that a lot of the challenges you had previously under the present Arbitration and Conciliation Act, a lot of those loopholes have been plugged. So I'm sure we'll get very soon, once the bill is passed into law, I'm sure we'll get to the position very soon where a lot of these challenges we'll see will begin to fade away, and we'll begin to see that people who have award creditors begin to reap the benefits of the award than they do right now.
Okay, another question from Halima El Alawa. How do you commence a practice in arbitration, especially when the field seems to have been dominated by certain senior lawyers, so much so that young lawyers are intimidated?
Very good question. But I mean, Halima shouldn't forget that the senior lawyers today were once young lawyers themselves, and they had to build themselves up. They had to work their way through, to build a successful arbitration practice. I think I spoke to this issue earlier when we were during the interview. You understand? So she has to be intentional. She has to be focused. She has to get the expertise, and then networking and professional contacts are very, very important. Go get to arbitration and workshops and seminars and attend trainings. These are very important. Once you get the first appointment, either as counsel or as arbitrator, give it your best. Excel in it, because that will give you a repeat appointment if you excel well, and if your other panelists can find that, oh, this person is really good at what he or she is doing. So competence is a very key factor. And like I said previously, you need to get to know in-house counsel. It's very, very important, because without those relationships, I'm afraid you will not be able to build that successful practice that you crave for.
Okay, thank you so much, Godwin. I think there is a comment here that there's no name, but I think it's an Xperia. Sorry, just it is an Xperia telephone, and it says, from what the moderator has just said, arbitrators should just keep capping the cost. Very effective. Yes, that is the strongest power arbitrators have got, tool they've got in their toolbox to deal with counsels who are not behaving themselves. The next question again is, the next question is from Kevin again. He says, sorry, Kevin Metzer again. He says, absolutely, that is the response to the question, Godwin, absolutely, but one must start somewhere in addressing the inequality issues. surely it is a commercial decision that is informed by the desire of the parties to do business. I'm not sure if you have to comment on that. Again, thank you.
That aligns with my thoughts, yeah.
Yes, they agree with you. And that takes us to the end of the questions that we have here. Have you got the final words to say in light of the questions put to you generally and from the attendees?
Yeah, my parting shot would be that I think we should be optimistic about the future of arbitration in Africa. We should be unrelenting in our quest to pursue diversity in arbitration in Africa. It's very, very important because, like I said, the statistics are not looking very good for Africa. So we need to continue to pursue that part. And then, of course, with African arbitrators, we need to continue to showcase our competence, our expertise, our experience, either as counsel or arbitrators. This is very important because ultimately that is what will help us overcome the passive bias. That will help us change the narrative, in terms of having more African participation, either as either men, women, young ones in international arbitration. So this will be my parting shots. Thank you.
Okay. And how are you going to keep us informed about the Court of Appeal decision in the global gas case?
Oh, probably I will, as soon as we'll keep tracking it, and as soon as the division comes out, probably we'll do a newsletter, some bulletin or some blog about it, But I'm sure that that division will be overturned. It's a bad division, and I'm sure it will be overturned. So, but I'll keep you guys in the loop of what happens. Definitely.
Okay. Thank you so much, Godwin, and thank you for giving us your time and plenty of information, and also for the good work you do in Nigeria, especially the equality. We like to see more women involved. We like to see more young people involved, and you're doing just that. So thank you so much. You're holding the flag up. And can I just say to the rest of our attendees, so thank you so much for joining us today. As I said in the beginning, this is one of a series of webinars, conversations that AFA is organizing. And this is just the second. So watch out for the rest. They're all very useful. And if you have any questions, any comments that you would like to be addressed, you have the email address of AFA. You can send details, you can send your comments or questions to them, and no doubt they will get to the right place. Also, again, to acknowledge to commend the fantastic work of Dr. Rukia Baruti, the Secretary General of AFAA, who has made it all possible for us to have this event. She does a great job for AFAA. And if you ever want to think about how to start on in your arbitration life and so on, always feel free to drop a line to AFAA, and she will promptly respond with some helpful information. And finally, I'll want to acknowledge the presence at this webinar of the President General of AFAA, Chief Bayo Ojo-san, who is powerfully leading the organization from the front. There is going to be the AFAA annual meeting, the one that was canceled this year due to COVID-19. It is going to be next year again. Exciting thing, as Godwin said earlier on, if there's any one event he's going to recommend is AFA event. So watch out for the AFA event coming up next year and try to attend. On that note, and as we hit the one hour mark, in a few seconds, I am going to say goodbye and see you next time. And thank you again, Godwin, for coming.
Thank you for having me, Julius. My pleasure. Thank you.
Okay. Bye-bye.